This conference will now be recorded.
I'd like to call this meeting to order. Town clerk. Sorry. I'd like to call this meeting of the Board of Adjustment to order. Town clerk, please call the roll.
Member Z?
Here.
Member Martell?
Here.
Member Sloat?
Here.
Member Lipscomb?
Here.
And Chair Enden.
Present.
And members are absently noticed.
Thank you. We all stand and say the Pledge of Allegiance.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
The proceedings are now called to order on agenda item number 1, a quasi-judicial hearing to consider the variance request for 8 Inlet Cay Drive. Town clerk, can you please read the agenda item?
It's an application submitted by Albert and Patricia Thrower as owners for a parcel of property located at 8 Inlet Cay Drive, Ocean Ridge, Florida 33435, requesting a variance from the provisions of the Land Development Code, Chapter 64, zoning, Article 4, marinas, docks, and bulkheads, Section 6477B, location, type, and height of docks, floating docks, and pilings to permit a floating dock to be located 3 foot from the property line as at east end of seawall rather than 10 foot. Also, Section 64-77D to permit kayak racks to be constructed on the floating platform, which is normally prohibited.
At this time, any ex parte communication should be either disclosed by identifying the subject of the communication and the identity of the person, group, or entity with whom the communication took place, or any correspondence be provided to the town clerk and be made part of the public record. In addition, each member of the board may identify the existence of any investigation or site visits he or she has conducted, or any expert opinions received, and disclose any conflicts of interest on this matter.
I visited the property, Mr. Chair. I walked around with the petitioner who showed me where she wanted to place certain items, and I thanked her and left.
Thank you.
I did the same. I visited the property, spoke to the petitioner, and looked where, walked along the seawall and just oversaw what we were coming to as a topic here today.
Thank you.
I answered a phone call. Turned out it was a petitioner inviting me to come look at the property. I didn't say anything at that point, responded. There were some texts to arrange for the visit. We didn't discuss the project at all. I then visited the site when the petitioner was out of town.
Thank you. John?
I visited the site yesterday with nobody present. So.
Thank you. I have visited the site twice, once with the initial, prior to the initial hearing, and again prior to this hearing as well. Okay. We'll then proceed with the hearing on this matter. Will the town clerk please swear in the witnesses?
Will anyone wishing to speak on this item, please stand and raise your right hand.
Jesus.
Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
Yeah.
When you are asked to come to speak, please state your name and address clearly for the record and whether or not you've been sworn in.
The town staff will now make its presentation on this matter.
Good morning, Chair, board members. Corey Foreman, town planner. I have been sworn in. This item was continued from your May meeting, and as was indicated in the staff report, and as the chairman indicated as well, there's a request for 3 variances at 8 Inlet Cay. They're related to a floating vessel platform. 1 variance is for the side setback. 2nd variance is for the extension of the platform into the waterway, and the 3rd is for a structure to support storage of kayaks. The staff report provides the overview of the request, the staff's analysis of the 3 requests, also includes in the backup the application, the applicant's response to the criteria for granting a variance, and some additional documentation. The continuance from the May meeting was to give the applicant the opportunity to provide some additional information, and I'm just here to answer any questions that I can. The staff recommendation is to consider the information in the staff report, the testimony that you'll hear today, and the criteria for granting variance. Thank you.
Thank you. At this time, any member of the public who wishes to submit relevant information to the board may come forward and speak for a maximum of 3 minutes each. Please indicate whether you are for or against the project, or neither for or against the project.
Terry Brown, Hubbard, South. Normally, you would wait until after you had your discussion to ask people to come up and make comments. That's usually the procedure on these matters. So when you finish, you ask for public comment before you go into executive session.
Thank you. The applicant will now make its presentation on the matter.
Hi, Carolyn Cassidy, 7 Hudson. I was on the Board of Adjustment with several of you in November of 21 when we approved the variance request for this very same floating platform. Nothing has changed with the structure at all. Subsequent to that, the variance expired and there were additional variances imposed on the applicant, which in reading through the references in the code, section 64-77, there's A, B, C, and D all talk about docks, and it's just a dock. When you get to section E, that addresses floating platforms or docks. I think perhaps what happened was when Mr. Guy visited the site again after the expired variance, he's looking at B and D and interpreting that to mean floating platform, when that might be questionable. And maybe that's something we need to look at in our code. But like I said, nothing's changed. We approved it the first time, and it just seems like this has been a very onerous, drawn-out process for the applicant. Thank you.
Patricia Thrower, 8 Inlet K Drive. I am the applicant, and I have been sworn in. And I would like to thank each and every one of you for sitting through this patiently again for the 3rd time, and I apologize that we have to go through it. But for some of you who are new to the board, perhaps I could just give a very brief background. In November of 2020, we hired a marine installer to place a floating platform for our kayak and paddleboard. I did ask for it to be installed west of our boat lift. He objected strenuously, saying it would be too dangerous for us and our grandchildren to get on and off with all the wave action from the intracoastal as well as the current in the area. We have a corner lot, there's a lot of current there, a lot of tide variations, and certainly a lot of boat waves. Also, he pointed out, should it ever break loose, with our exposure to this wave action and our proximity to the intercoastal, it could prevent a true navigational hazard. Based on his strong recommendation, the floating platform was placed directly east of our boat lift, as close to it as possible. He assured us at the time no permits were needed, as it was only a 10 by 10 floating structure secured by one pole off of our seawall. It was in place for 6 months before any problems were encountered. Number 6 Inlet K, 2 doors east of us, installed a jet ski platform in a spot that number 7 Inlet K objected to. Number 7 called the town and complained, and within a week, both number 6 and number 8 had citations for installing platforms without permits. We didn't know we needed a permit. We immediately came to town hall and went about trying to find out what was required to get the permits, and discovered that we needed a variance as we were 3.5 feet off the property line. We applied for this variance and were granted such by yourselves on November 17th of 2021. On November 24th of 2021, we came back to Town Hall. I was given a list of requirements to fulfill, and we went to work immediately. We tried to reach the DEP. This took several months. Let me refresh everyone's memory. It was Thanksgiving, Christmas, New Year's, and COVID. No one was answering phones at the DEP, and a lot of people were working from home, and it took a long time to even get an email response from them. I mean, I'm talking weeks and weeks and weeks of doing this. We went about getting the other information we needed. In the meantime, no one told us we had to move the platform from its current location until we got the permit. So we were fined $1,200 for not moving it. We didn't even know we had to. We hired the same marine installer. He said that it was really covered in barnacles and almost impossible to move without harming his workers. I really cajoled and begged him, and he pulled it behind our boat out of the way and tied it with 2 ropes. It is still tethered there today. From November of 2021, it is still there, bobbing and weaving, causing an intracoastal hazard, if I may say so, being hit by many boats going by and other kayaks and fishing boats. It's really a miracle it hasn't broken free. It's been bumped by our boats and many others traveling in and out of the South Canal. In January of 2022, after hearing from the DEP, we had to hire a coastal engineer for $5,000 to get through the DEP process. In February, we had another meeting with Mr. Guy to be sure we had all the other requirements for the permit. We submitted all our documents, engineering drawings, surveys, photos, and the only thing we were waiting for was the DEP approval. Then Mr. Guy said he needed another engineer to do very specific drawings of how the bracket attached to the seawall. 1 bracket, 2 screws, an engineer drawing cost us $1,500. And another updated survey, $2,500 again. The DEP said they had to wait for June, July, and August to see how the seagrass was growing in the area to determine if the floating platform would impact it. In August of 2022, we did get the DEP approval. They said it was not going to be a problem. So we thought we were all set for our permit in September of 2022 and came back to meet with Mr. Guy. He said we would never get the permit because the dock extends more than 5 feet from the seawall. This was told to us after 10 months of meetings, phone calls and emails, and over $10,000 spent trying to comply with all the requirements that we were told about. In addition, we were fined $3,000 by a magistrate. As an aside to all of this, just because life is never simple, all the pipes under our house fell. We had to move out of our house, completely clear out every item on the first floor, put all our furniture and records in storage. We had to move back to New Jersey in May of 2022 after vacating our home. We then took a rental home in Delray from January to May to come back to oversee the reconstruction of the first floor of our home. In the midst of all this, with no access to our records and all the upset of the dislocation, the variance that was originally granted in November of 21 expired. We received no email or no notification that the variance was expiring. I apologize, I'm from New Jersey. Variances in New Jersey don't expire. They just, I get it. Again, because of the turmoil in Town Hall, Carla Armstrong was a very big proponent. Mr. O'Gorman has been more than helpful with us, but we really lost our friend and ally, Carla, who was helping us and alerting us to these things. We came back down in January of 23. We again went to Town Hall to proceed with the permitting. We find out the variance has expired. We now need 2 more variances. One for the platform extending 10 feet and another for the kayak rack. It was almost overwhelming, honestly. When Mr. Guy told us we would never get a permit, we asked, did everybody else in Ocean Ridge have permits? Because in driving our boat around, we saw lots of these structures, lots of kayaks, lots of wave runners on different types of floating docks. We were told that the only permit for any dock in Ocean Ridge was the 100-foot dock behind the Wellington Arms, which is for 20 boats. So I'd like my husband to show some pictures so that you can get some sense of what we're talking about. The first picture is a picture of our home, and it shows the floating dock in place. This was taken in November of '21. I think, as you can see, it is secured by one pole that floats up and down. The kayak rack is less than 4 feet high. This is important, and I'll tell you why when we come to the variance. The kayak and the paddleboard are well below our seawall, and in this photo, slightly below number 7's seawall. In addition, I think you can see there's a ficus hedge there. But the next picture will show a current photograph. That is the size of the ficus hedge currently. And if you can just lower that down, can you see that? That hedge is 11 feet high at the moment. And if you'll move it up and to the right a little bit, over, you can see where my arrow is. Other way.
Yeah.
Up. This is where my floating platform is. So I know that number 7 said it impedes their vision of the intracoastal. I don't see how it possibly could. It's below our seawall, it's very far over, and they have a ficus hedge there. I think we can go to the next picture and show some photographs of existing structures. This one on Spanish River. I'm sorry, this is River Road. I have them all labeled. Maybe you could call out the address. This is on River Road. Again, no permit. Next. This is 45 Bimini Cove Drive. Exactly the same floating platform as ours, and it's right on the property line. This is 5 Inlet K Drive. You can go the other way. I think it's, yeah. That's also right on the property line. That's another one at 52 River Road. With kayak racks and paddle boards much higher than mine. Another one right on the property line, 12 Sable Island Drive. "52 River Road, a large dock extending further out than ours. "87 Island Drive South, another large platform with multiple structures on it. And another one on River Road. So I think you get the picture that we are not the only people in this situation. In January of 2023, my husband Al met with Lynn Ladner to find out what was going on with our permit. Mr. Guy came out. He said the variance expired. We are now past this 5-foot limit. Lynn Ladner talked to the town attorney, and she would not extend our variance, so we had to come before you again, and that's why I'm here today. Mr. Guy also said we have a superstructure on the platform. In your own town code, which I'm sure you're all familiar with, a superstructure is something that extends higher than 5 feet. Our kayak rack is under 4 feet. This is also Florida code as well. So we started the process again, and here we are. I can go through the variance application, which is, as you know, code 6477, B and D, which states that the dock shall not extend more than 5 feet into the waterway. This, I believe, according to Christie, is this correct, that this has been taken out of today's application because of the new Florida state law?
What is that?
You sent us a paper saying that because the Florida state law had changed, that part of the variance we didn't need today, is that correct? Or should we go through the whole thing for the 10?
5 feet extension into the coastal.
I haven't issued any opinions onto whether or not we need a variance in this.
Okay, so, but what you sent me only said for the 2 variances, not the 3. But we'll do it, it's fine.
Okay, I'm not aware of correspondence directly with you.
You sent an email to my husband?
Okay, to your husband. Do you know when that was?
No, the email you got was from the town.
From the town,
The meeting.
okay, I don't know who sent it.
Okay.
That was the notice for the meeting today.
Okay,
It didn't-
all right, well, we'll start from scratch and we'll do all of them, it's fine. So, let's start with, so now I'm gonna go back to the 3 variances, okay? The variance 1, to allow the platform to within 3 feet of the property line. This variance was already approved in November of '21, but I'll go through it for those people that don't know. The property is located on the southwest corner of Inlet K Drive and it butts the Intercoastal Waterway. As I stated, our property is exposed to boat traffic and severe wave action from large boats that transit the Intercoastal daily, often at quite high speeds. Many of these boats pass close to our seawall. Unfortunately, we're not located in a no-wake zone. Therefore, boats of all sizes pass up and down the Intercoastal, sending large waves into our seawall. Across from the property, on the south side, is a mangrove area that is very shallow, and it forces the boat traffic to pass close to our property to avoid the shallow water there. The boat traffic also generates waves traveling into our seawall along the south side of the property. Therefore, the location of the floating platform was chosen to be on the east side of the existing boat lift to minimize the effect of boat waves and waves on the floating vessel platform. And this unfortunately requires us to be within 3 feet of the property line. Number 2, the variance for the platform to project 10 feet from the seawall. We need this floating platform to safely launch the kayak and the paddleboard for our children and grandchildren to use. Our dock is approximately 8 to 10 feet above the water. And of course, depending on tides, it could be 8 feet below or 10 feet below. But the height makes it impossible to launch a kayak or paddleboard from the dock, obviously, especially with small children, and then to get them back up safely. The size of the floating vessel platform is 10 by 10. That was the size recommended to provide stability while walking on the surface and to resist the tipping from side to side when you get the kayak down. We also need to climb down onto the platform from a ladder and position the watercraft prior to launching it in the water. Variance, this is important to avoid slipping and falling when launching the watercraft. Therefore, we need the variance to extend beyond the 5 feet limit out to the 10 feet limit. My husband's going to address this issue because the Florida law is changing or has changed. Variance 3, allowing a rack for kayak storage. Secure storage of the watercraft is important so storms or wind do not dislodge the boats. They would then create a navigational hazard floating around the Intercoastal. The height of the storage rack is, as I said, just under 4 feet. So I did think Mr. Guy interpreted this incorrectly and asking us for a variance on this, and Carolyn also pointed this out in her discussion. So the special conditions are variance 1. We are located where we're located on the southwest corner. We're exposed to wind, waves, and boat traffic. The proposed location is the most protected from waves and storm action. Sudden rocking of this platform is a fall hazard for anyone, myself, my children, my grandchildren, and therefore locating it anywhere along the seawall to the west of the boat lift exposes it to severe wave action from passing boats and storm. The marine installer emphasized this in choosing the location to avoid exposure to waves and the current. Again, his thing. Allowing the platform to project 10 feet from the seawall. This is a minimum for safe use. Some wave action is inevitable due to passing boats, but the 10 by 10 size provides stability when walking around and getting out the kayaks for use. This is important to avoid slipping and falling. We have 8 grandchildren and feel that safety is a primary concern. And variance 3, I'm not sure it applies because the storage rack is under 4 feet. So I don't think we need this variance, but we're here to get it anyway, just to be sure. There are no cleats on the floating vessel platform to tie down the watercraft, and the rack was the suggested one from the marine installer for safe and secure storage of the watercraft. We also checked with the Florida state law. The new state law that is in session right now, and they're voting on it in July, says it is important to have safe storage for watercraft. You can't just have them hanging, like some of the pictures, hanging off or tied by a string. So this is what we did to provide safety. The granting of this variance will not confer any privileges that is denied by the zoning ordinance to other lands, buildings, or structures in the same zoning district. I also want to stress that the kayak and the paddleboard are put away in May and don't come out again till the end of October. So for hurricane season, they're not even there, they're put away. I think that's everything. And did you want to address the Florida law?
Oh, somebody has a question.
Does anybody have a question about the current Florida law? In addition, I have letters, I don't know if this was in your packet, all of our neighbors, all of our direct neighbors, with the exception of number 7, have written letters of support for this variance. I just got one in the mail today, which is from number 6, Scott Padros, which I will share with you because it just came today. He's number 6 in Inlet Cay. People on either side, with the exception of number 7, everybody has written in support of us. So I also have, I think the board asked to see that I have pictures and drawings that were, okay. I believe it was Martin Busholi, I don't know how to say his name. He made a comment at the last meeting that we moved our dock. Of course, that's not true. The dock was actually approved by Durante Guy when we did the new seawall, and we have drawings and everything approved by the town, signed off by the town, that none of this was done. You'll see at the bottom, final past engineer letter received and accepted, Durante Guy. That was August of 2020. Okay. And this was in the same position. I want to see any of these. Sorry.
Speak about that.
That's just the final approval. We had to redo our seawall. It was in terrible shape. It was leaking. It's still, twice a year, we have a company come back. B&M Marine comes back twice a year to repair all the seams in the seawall. We get buffeted by waves that you would not believe. And some of you did have the opportunity to walk around the property to see that there's a lot of settling on our property. Our pool has dropped. Our hot tub area has separated from the rest of the pavements. The pavements, particularly around this area where the dock and the floating platform are all uneven, raised up and down. We have a bricklayer come once a year to fill in more sand and land and structures because it's unsafe. If someone doesn't live on the water, like Martin, they don't understand what it's like to live in this area, which is basically, we're built on muck, if I can use that word, that was dredged from the Intracoastal 45 or 50 years ago, and that's what my building is on. I didn't know this when I bought it. Trust me, this has been a nightmare, beyond belief, and very costly. So when he comes up and very gallantly says, you can move it here or here or here, it simply can't be done. It's not reasonable, it's not feasible. So I'm imploring you to please pass these variances so that we can, after 2 years of not enjoying our kayaks and paddleboards, we may go back to enjoying them. I thank you again for your time and listening to me go on. Apologize.
Thank you. At this time, any other member of the public who wishes to submit relevant information to the board may come forward and speak for a maximum of 3 minutes each. Please indicate whether you are for or against the project or neither for or against the project.
Mr. Chair, we do have an affected party that's present. So for purposes of due process, we need to afford them the same opportunity to speak as we would the applicant.
Certainly. Affected party or their representative?
Yeah, absolutely. Be happy for any other public comment to go first.
Evidently, you're up.
All right, very good. Good morning, everybody. Thank you to the members for this opportunity to address the board again on this issue. My name is David Glickman, and I'm an attorney at the Markarian Group, and we represent Gilbert and Nancy Florentora, who are 45-year residents of 7 Inland Cape Drive here in Ocean Ridge. They oppose the variances sought here today by the throwers relating to their property at 8 Inland Cape. Just for orientation, Lot 8 is a corner lot, and it's on the east side of the Intracoastal. It's off of one of the canals that runs east from the main channel of the Intracoastal, and then Lot 7, the Florentora's house, is just east of Lot 8. And the floating platform that's at issue was already constructed. It's in existence today. It's located right now west of the throwers' boat lift. The platform was originally constructed by them to the east of their boat lift, closer to the Florentora's home, without a permit. And it included fines until it was moved to the west of the boat lift, where it has remained for over a year without causing any safety issue whatsoever. Now, as an initial matter with respect to the technical aspects of the application was actually made for administrative variances, if you read it closely. And the code notes that an administrative variance is one that's applicable only to grandfathered uses, lots, or structures. And there's no mention or any evidence in Lot 8's application to show that the variances they seek here are related to a grandfathered use, lot, or structure. Quite the opposite, where the variances relate to a structure that was actually originally built without a permit in violation of the code. And so we take the position this morning that the use of an incorrect application itself should require denial of the variances. But more substantively, we'd like to discuss the 10 criteria that each variance must meet in order for you to grant them here today. Those are criteria A through G, and they are required under section 6373B of the applicable code. Now, you'll note that the applicant's verbal presentation appeared to fail to address all 10 of those criteria that must be met under the law for each of the 3 variances. And if you look closely, the written application itself only contains a very short paragraph with regard to each factor, and in our view, fails to successfully show why each factor is met. Part of our submission here today, which I believe has already been made, but I will provide it to the town clerk just again to ensure that it's made part of the record, contains correspondence setting out our position in full, together with a number of exhibits that I'll refer to here today. But that submission, part of it includes a PowerPoint presentation that was previously presented by the town attorney, Godot, that did specify that each variance must meet all 10 criteria required by section 6373B, and that even if a single criteria is not met, the board must deny the variance under the applicable standard. And here, in this case, even the town's own staff analysis identifies a number of criteria that are not met in connection with the 3 variances. And so with regard to each criteria, we believe that criteria A fails because there are many other homes here in Ocean Ridge that front the Intracoastal. Lot 8 has not identified in its response any unique circumstances that those other homes fronting the Intracoastal don't experience. Moreover, the staff in their analysis of this criteria accurately noted that the request for a superstructure doesn't actually relate to Lot 8's land. And we take the position that the issue of wake raised by the applicant as well doesn't relate to its land, but instead they both relate to the waterway and the use of the waterway, not the actual land itself. Variances are required to be related to use of the land. Criteria B is a crucial one, and it requires that you as the board find in connection with all 3 of these variances that the special conditions and circumstances being discussed do not result from the action of the applicant. Now remember, we zoom back out here. What Lot 8's really asking you to do is to let them move the platform from the west side of their boat lift over to the east side of their boat lift, closer to our client's home. Criteria B, that the special conditions and circumstances do not result from the actions of the applicant, fails. Because as Lot 8 just admitted in their presentation, they actually installed the existing boat lift in its present location. Now, during the construction of that boat lift, they chose to put it just about as far east and as close to Lot 7 as they possibly could within the allowable setbacks. That is why there is no room today east of that boat lift within the allowable setback for them to put their floating platform, and why they are here requiring a variance from you. That is why they quote unquote need a variance. The need was self-inflicted. Had they placed their boat lift any further west on their property line, there would be room within the allowable setback for them to place their platform east of that boat lift. These were affirmative choices and voluntary decisions made by Lot 8 that have reduced the space available to the east of that boat lift, and which prevent them from putting their platform east of the boat lift within the required setback. These special conditions result from actions of the applicant, and criteria B clearly fails. Now, moving to criteria C, it also fails because granting the variances would indeed confer special privileges on the throwers. In fact, your staff in its analysis identified 3 special privileges that would be conferred on the throwers should you grant these variances. Number 1, it would enable the platform to be located closer to my client's property line with it than the allowable setback permits. Number 2, it would permit the platform to extend further into the waterway than is permitted by the zoning ordinance when there are already navigational issues for boats in that part of the canal because it's so narrow. And here they want to your permission to actually extend something further into the canal. Number 3, it will permit the it will permit the platform to contain a superstructure, which is expressly prohibited by the zoning ordinance, as noted by staff in its analysis. Now, you heard a lot of discussion by the applicant and some other folks about a prior variance. And we believe that that discussion is a red herring meant to distract you from the application that's actually in front of you here today. The prior variance lapsed and expired after Lot 8 was unable to obtain permits. That prior variance lapsed and expired after Lot 8 was unable to obtain prior permits to implement it, despite obtaining one or more extensions to obtain those permits. Now, we take the position that that former variance was actually improperly granted, and that the only relevant consideration here today for you is the applicant's response and the applicable criteria to the 3 variances sought today, not the board's previous actions. We believe the former variance was improperly granted because it was based on inaccurate measurement information. We're talking about principally the side setback between the properties. And Lot 8's previous permit requests included different measurements for that area. We're talking about the area between their boat lift and my client's property. Previous applications by Lot 8 show a distance of 12 feet, a distance of 12.7 feet, a distance of 13 feet, and most recently a distance of 14 feet. Now, the true distance is 12 feet, and we take the position that it's mathematically impossible for a 10-foot wide dock to be placed in a 12-foot wide opening and maintain a required 3-foot setback. And so, because the board didn't have accurate information about the total space within which the structure was to be put in the prior variance, it improperly granted it. But regardless, that variance is no longer at issue, and you should focus on whether or not the 3 applications in front of you meet all of the required 10 criteria. Moving to criteria D, we believe this criteria fails because your staff analysis specifically notes that literal interpretation of the setback requirements would enforce the same standard that is applicable to all other properties in the same zoning district. The granting of these variances, members of the board, would actually impermissibly provide Lot 8 with more rights than are enjoyed by similar properties within its same zoning district. Also note that Lot 8 failed to claim or provide any evidence of unnecessary and undue hardship as required to meet the variance standard. Lot 8's application doesn't identify any factor outside of its control that results in a hardship sufficient to meet the variance standard under the code. Remember, ignorance of the law is not a legal defense to violation of it, or for failure to meet the applicable standards. Also, the existence or the absence of variances relating to other homes is not relevant to the board's consideration today. Just because other homeowners are violating the town code does not mean that you should absolve Lot 8's violation of it as well. Now, variances are also not necessary under the code when alternative options exist. Lot 8 has failed to present competent or substantial evidence that there is a bona fide need to relocate this platform to where they seek to do so. They have not shown that they're unable to modify their existing boat lift or their existing dock to avoid the need for a variance. Their application, in fact, doesn't contain any statement about any efforts they made to explore alternatives. When in fact, Lot 8 does have multiple options and alternatives available to it that would adequately address their safety concerns and their goal of being able to safely launch kayaks. Those alternatives wouldn't require the granting of any variances, and they wouldn't negatively impact Lot 7's property rights like these would. At least 2 options exist that we identified. The first are called wave attenuators, which effectively work to stabilize floating docks and prevent excess rocking and rolling that may be caused by wave action. We include a link to a website where the public can purchase these at relatively inexpensive options in the materials that we submitted to you. Second option and alternative is very interesting. It's to obtain a kayak launch lift that attaches to the seawall. Now, this permits a kayak to be stored out of the water and to be placed easily into the water when it's going to be used, similar to like a small boat lift. Now, what's most interesting about this option is that the home that's located just immediately north of Lot 8, which is also a corner lot fronting the Intracoastal, actually has one of these on the Intracoastal side, the Intracoastal channel side of its home. It has a small lift located on that channel side, and there have been no reports or concerns regarding safety or use of that small lift. Exhibit H of our submission here today shows you a photograph of that small lift. And we take the position that the throwers could put one of these lifts anywhere along the various feet of their seawall, whether fronting the Intracoastal or on the canal side. Now, criteria E fails because no variances are actually required in order to make reasonable use of Lot 8's land. Similar to my comment earlier, consider closely again the issues that Lot 8 brings before you. The issues relate to their use of the waterway, not the actual land. As we discussed, the conditions here are self-imposed by Lot 8, and we include some exhibits and photographs in exhibits B and G in our submission that show how this structure would impose on the view of Lot 7. And we also include in exhibit G a letter from a local realtor who provides his professional opinion that the requested variance would actually negatively affect Lot 7's property values and property rights. Now, the last two criteria fail, F and G, because if the use was in harmony with the general intent of the ordinance, then no variance would be required. And the proposed use would permit this eyesore structure to be placed directly in Lot 7's water view, and again, would negatively impact Lot 7's property rights, including its property value. Now, the hedge that was mentioned was actually installed specifically to combat the effect of the installation of the structure on Lot 7's view. So that was in response to the original improper placement of the lift to the east of Lot 7's boat lift, in response to the actions taken by Lot 7. The staff noted several instances with respect to criteria F and G where the proposed use is not in harmony with the general intent of the ordinance that's applicable. And therefore, when each of these three variances are independently measured against the 10 required criteria to legally grant them, it's plainly obvious that each separate variance separately fails to meet all of the required criteria for a multitude of reasons. Remember, each variance must meet all 10 criteria. And therefore, because each variance does not meet all 10 criteria, it is not legally proper for you to grant any one of the three requested variances. Now, one of the reasons this board voted to table this issue at the last meeting was to receive additional information, including about safety. And the Foreign Authorities listened to the board, and they consulted with a marine expert and local 40-year marine construction veteran, Larry Robbins, who runs the company Docks and Seawalls. Now, I believe Mr. Robbins is here today, and we include in our materials at Exhibit C, Mr. Robbins' affidavit that attests that based on his expert review of the circumstances, there would be no discernible difference in the safety of the floating platform, whether located on the east or west of Lot 8's boat lift, so long as the floating platform is installed correctly. He also identifies in his affidavit some of the viable alternatives that I discussed earlier, which we urge you to consider. Now, there was some discussion about a new law or change in Florida law, but I don't believe the proposed law was even identified, and I believe I heard a comment that it was still in session and is to be voted on in the future, and therefore we take the position that law is not effective and it cannot be considered in your decision here today. And so therefore, for the Board of Adjustment to legally grant any of the three requested variances, again, it must make three separate analyses and determine that each of the requested variances does in fact meet all 10 of the required criteria that we went through. And based on all the foregoing reasons that we've discussed here, and at least in part from the town's own staff analysis, it is clear that Lot 7's application fails to meet all of the required criteria for each variance, and its application should therefore be denied. Thank you for your time and consideration. Happy to answer any questions.
Any other comment from the public?
Thank you, Mr. Chair. Terry Brown, Harvard Drive South. Not that it's real important, but I did serve on this board for 10 years. Victor was there at that time, many, many years ago. And one element, I haven't retained all the information of all the cases that came in front of us, but one vital piece of information is that you cannot create a hardship, a self-inflicted, as the representative so eloquently pointed out, and then come in and ask for a variance of a hardship that you yourself, as the applicant or homeowner, created. Like, I would deny all three of them. Thank you.
Carolyn Cassidy, 7 Hudson. With respect to Mr. Glickman's comments, it's actually Senate Bill 1082, and you can pull it right up on your phone, and it does address floating platforms. They can't be in excess of 500 square feet. This one is 100 square feet. And it also says that the structure may not be subject to any more stringent permitting requirements, registration requirements, or other regulation by a local government. But my big question, when we reviewed this back in 21, Bruce, you'll probably remember, and Bob, the whole subject of whether a permit was required came up. And Girani was a little stumped at the time, and he and Carla spoke and came back and said, a permit for a floating vessel is not required, but they are still subject to variances. So, for variance requirements, which probably explains why there are so many throughout Ocean Ridge. If people know they don't need a permit, maybe they don't know they need a variance when they install it, so. That's it. Thanks.
I do have a letter to read into record.
Pardon me?
I have a letter to read into record.
Sure, please.
Your duties to the town of Ocean Ridge are clearly defined. The Board of Adjustment shall only grant variances to residents when all of the outlaid criteria is met. Not one, but every single one. In the case of the owners of 8 Inlet K Drive, this cannot be said about really any of the criteria. Let's be clear about that. A hardship is something that is unique to your property. Being a point lot, as 8 Inlet K is not unique. In fact, the owners of 9 Inlet K Drive have jet ski platform attached directly to the intercoastal waterway, despite having access to the canal to the north of their property, where they share an almost equal length of the Inlet K Drive. 8 Inlet K Drive. On the island to the north at 22 Eureka Drive, the owners put their jet ski platform on the west side of the property. 24 Eureka Drive, the largest waterfront estate, shares a long intercoastal waterfront as well as 2 canal sides, and the owner's platform is still much closer to the intercoastal than this variance request by 8 Inlet K. By granting a homeowner such as 8 Inlet K Drive a special exception, especially one that can easily be remedied by the homeowner himself by simply reducing the size of his dock or moving it over 10 feet, or opting for a different type of platform, one that would be moved up and down with a motor. By granting such a variance, you are taking the neighbor's rights away from them. Your decision literally means that you are impeding into the line of sight of the neighbor, reducing his property value. You are also reducing his maneuverability access for his own watercraft when bringing it in during choppy waters, putting the neighbor in danger of impacting with the dock or the platform you just granted a variance for. There is a clear reason why the side setbacks have been implemented. In this case, for safety of the neighbor's boat access and to protect his property rights, which do include the unobstructed views. Again, none of the criteria have been met to grant a variance, not a single one. The applicant has to meet not one but all. By granting this variance, you'll be put into the town in a position where it will have to defend itself in court. The owners of 7 Inlet K surely will file an appeal to your ruling in court, and there for sure variance will be overturned. The homeowner then can possibly ask for attorney's fees, since the Board of Adjustments, when granting a variance, they have been clearly advised does not meet the town of Ocean Ridge variance requirements. You are putting the town at financial risk. Martin Bishalek, 8 Eagle Drive. 5 Eagle Drive.
Thank you. Sure.
I'm Al Thrower, 8 Inlet K. Just wanted to address a couple of the issues that were raised. First of all, as a point of history, we purchased this home in 2003. The boat lift was there, the dock was there. We came to find out at the time of the closing that the dock was not permitted. This created obviously a bit of an issue at the time, and we were concerned we were buying a house that was in violation and not properly permitted by the town. At that time, the previous homeowner agreed to follow through and get it permitted. That took more than a year for him to get through the various agencies. The town has all those records, and the dock was permitted and the boat lift was permitted, and that was legal. Once we were required to do our seawall renovation, as you probably are aware, we filed the necessary paperwork, which you just saw from the Department of Environmental Protection and the Army Corps. They approved the existing dock and the existing boat lift. And they are basically exactly where they were before, within a matter of several feet. So this is not something we are allowed to move. It is a structure that has been placed where it's been placed based on prior approvals from other agencies, and we're not just allowed to just move our dock or move our boat lift wherever we want to willy-nilly. So that's number one. Number two, we had a survey done, updated survey done at the request of Mr. Guy. The details have been provided to the town, they have all of it. And there is enough room for the dock there. It turns out that the property line, it was a little bit closer to the Fortunas or to the number 7 than we thought. And there is room for the floating platform. I'm happy to provide a diagram, which I'll give to the, and this shows the proposed location. This is in the application, and it shows the proposed location and that there is indeed sufficient room for the floating vessel platform. Number one. Number two, as far as the law is concerned, there is currently an existing law that is in force, and that is statute 403.813. That is the current law in the state of Florida. That is proposed to be modified in the proposed law, but it has not passed yet. The current law was provided to Mr. Guy when we were in the process of doing this. And I told him that I thought at the time that law, because it states that local towns cannot exceed the authority of the state on whether these floating vessel platforms are permitted or not. He disagreed. And he said that, that we still had to follow this 5-foot setback, even though the state of Florida says that once you get the exemption, the water, which belongs to the state of Florida, not to the town of Ocean Ridge, once they agree to allow that, you meet the exception, and we did meet the exception. But he disagreed, and he said, you can't go more than 5 feet. Now, this doesn't make a lot of sense when you think about it, because every floating vessel platform in the town that is used, almost all of them stick out more than 5 feet. Because wave runners are longer than 5 feet, and most people dock them perpendicular to the seawall. So I think in retrospect, I think that, in my opinion, the 5-foot restriction applies to a dock, not to a floating vessel platform. That's open to interpretation, I understand that. But regardless, as far as the law is concerned, I think and you can look it up and read it, I'm not going to go into great detail, but basically what it says is that if you meet the exemption, which we do, that a local ordinance may not be more restrictive than what the state of Florida says. Local ordinances can impose setbacks, that's reasonable, but they cannot impose restrictions on the use of the waters of the state of Florida. And that's where the 5-foot rule comes into play. Again, I don't think there's an issue with the spacing and the position of the dock. And I don't think, in my opinion, that there's an issue with the distance that it sticks out from the dock based on my interpretation of the law. Regardless, obviously all of these things exist in the town for the purposes of practical use. As far as these motorized lifts that people have and have been referenced, these are lifts that are used because these heavy pieces of equipment, such as wave runners, are thousands of pounds. They are not possible to be moved up and down manually. So people that want to move them up and down have to have a motorized lift. And there are people in our area that do have them on the intercoastal. That's certainly up to them if that's what they want. So we do not want a motorized lift to go up and down. It would be an eyesore for us and would be dangerous, lowering it down at the time that a large watercraft came by with boat wakes and sloshing all over the thing. So at any rate, the bottom line is we have submitted letters that have addressed some of these issues. We have letters from local neighbors, and I'll provide two. We have a letter from our marine installer, which I've submitted and is part of your packet, that addresses his location. Placing it where it is currently is very, very unsafe for many reasons. Plus, it is not giving us sufficient room for our boat to be launched. Cannot launch the boat eastward. The boat has to be launched westward. And therefore, we would have to move this floating platform even further west than it is currently located. It is in a temporary location, and would have to go even further west than it is. Can I answer any questions?
Yes. When I noticed when I went over the property that your floating platform now is pretty much just tethered to, so it doesn't float away. Is that
Can you
correct?
turn your microphone on?
It is, he just needs.
Oh, there's okay.
That's good. It's tethered so that it's just floating around. It's not tied to your seawall anymore, correct? Well, I mean, physically tied to the brace.
There's ropes that are attached to the seawall, and then there's another rope that attaches it to the piling that the boat lift is on, just to try to give it angular support. Yeah.
And since you've had to move it there, have you been able to use it, or is it just sitting in the water?
Well, it floats all around. It's
Right.
not stabilized.
Right.
So it's not very safe, number one. Number two, we don't have a ladder to get down to it. So the proposed location, we installed a ladder. So that the ladder is necessary in order to use this safely. Obviously, if the water was very high, you could get to it, but getting down to it from where it is, if the water is low, is difficult because it could be a drop of 3 feet, 4 feet from the seawall to get down to it.
Thank you, Doug.
Okay. Staff will now make final comments.
Mr. Chairman, we have no additional presentation.
You know, I have a question, actually, for Tom. I remember at the, I'm sorry.
say something, please?
Certainly.
You're sworn in and. My name is Fornatora, 7 Lecay Drive. In regards to this whole situation, I'd like to bring up a couple of points. There were numerous occasions where the throwers could have made a choice, such as when they bought the property, when they installed the wooden dock, when they put in a new seawall, then they put in a new dock, then they put in a boat lift, and the initial boat was right against our property line, which the town forced them to remove. So there were many occasions, but that's not the point. They were issued a permit to build a dock 70 feet with a 25-foot setback from the property line of 7 in Lecay. The permit was granted and everything fit within the 165 feet of seawall that they had. So that meant a 70-foot dock with a 25-foot setback. So any plans that you could have thought ahead to place anything you wanted to the east of your dock, you had plenty of room within 25 feet to stay within the town code of 10 feet. But the dock was built to 83 feet. Now, 83 feet cuts out the possibilities drastically, which means when you add up the numbers, there's only 12 feet available from the end of their dock to the property line to fit a ladder, which roughly takes 6 inches, a 10-foot platform, that's 10 foot 6, and then a structure which stores the kayaks and paddle, but it hangs over the edge of the platform by at least 18 inches, maybe it's 2 feet, I don't know. So you will see in your packet that we gave you the permit that they received, and they violated the permit by constructing an 83-foot dock instead of a 70-foot dock. And in addition, there's another picture taken from the county with an overhead view that shows the platform in place with the rack right over our property line or right on it, and from an overhead view coming from the county. Thank you.
Patty Thrower, 8 in Lecay. I'm sorry to keep beating this dead horse, but we purchased the property in 2010. The dock was existing. We replaced the seawall and we restructured the dock, meaning we took out wooden pilings and we put in concrete pilings. We did not move the dock. I'd like to stress this. The dock is where the dock is. The dock has always been where it's been since 2003, when the original owners, Robert and Janice Happ, built the home. The dock was permitted and signed off by Durrani Guy after the construction was completed, changing it from wood to cement. That's what we did. We didn't move the dock. This was all done from 2016 to 2020. As many of you know who have dealt with marine installers in this area, it's extremely difficult to get them to do the work, to come in a timely fashion, to get all this done. It took many years. It didn't happen in 3 to 6 months. It happened over a 2-year period, and the permitting was before that. This floating dock with the kayak didn't come into play until the very end of 2020, literally November, December of 2020. We thought about the floating dock. So all of this, what they keep referring to, is ancient history. and has no bearing on what we're talking about. In addition, in your packet, there's a letter from a real estate appraiser stating that this has no impact on the value of number 7's property. And again, from all the pictures I've shown you, it's not even visible 90% of the time because of low tide, hedges, and the fact that we don't even have the kayak and the paddleboard on there for 6 months of the year. Thank you again.
Mr. Glickman was.
Yes.
Nancy Fornatora, 7 McKay Drive, and I've been sworn
Could
in.
you,
And I've been sworn in to talk.
can you repeat it, because you were
I'm
talking.
Nancy Fornatora, 7 McKay Drive, and I've been sworn in. Thank you very much for listening to me. I think that you have in your packet that our attorneys presented to you the 2 permits that the throwers received for constructing a dock to replace the original 60 by 5 foot wooden dock. The second permit was for keeping in the same place a concrete dock that was 70 by 5 feet. However, if you see the measurements of the documents that have been presented today, you will note that the dock is now 83 feet. It grew overnight, and we do not have a permit. There may be one that exists, but we asked for all the documents and we did not receive one. So they now have an 83-foot dock, which mathematically leaves them 12 feet to place this platform that extends over to the property line. So there is no 3 feet left when this dock is put in place. So thank you.
Good morning, David Glickman on behalf of the Fornatoras. Just very briefly with regard to the movement of structures, a point of clarity on this point because it goes to the nature of the self-inflicted condition. The boat dock, well, let's say the boat lift for clarity, was indeed moved. If you recall, there was testimony that it was originally constructed right up against the Fornatoras property line, and the town actually made the throwers move it west. And so that boat lift was moved west. That was the point in time when the throwers had the opportunity to move it far enough west to permit enough room east of it within the allowable setback for them to place a floating vessel platform. They apparently chose to not move it far enough west at that point in time to facilitate enough room, thereby self-inflicting the condition that they're here requesting a variance for. The variances should be denied. Thank you.
Any other public comments? Yeah, thank you. Corey, I had a question. I remember from the first variance meeting that we had, there was an issue if the floating vessel platform was moored or attached, and the difference in town ordinances. Can you review that for me?
Yes, sir, I don't have that in front of me, but my recollection is that if the floating platform is not connected, not attached to the seawall, it does not need a permit. But if it is connected, if it is attached physically to the seawall, it does need a permit, which is at least my recollection of why we sort of are where we are.
Yeah. And I also remember, again, a lot of this was safety considerations that the bracket attachment, 2 screws and a hinge or whatever it was to prevent any potential of the platform or its contents becoming navigational hazards. Do you remember?
That's my recollection as well,
Yeah.
yes.
Okay, thank you. Any other questions?
Yeah, Mr. Chair.
One second. Have you made all your final comments?
Well, as sort of an odd aside, when Mr. Guy asked for the, I think it was third survey for this to be done, the last one, the surveyor came and put a marker to survey our property line. And I wasn't even gonna mention it, but since they keep harping on 6 inches and 5 inches, our property line is on the Fornatora's dock. And there is a marker there that any one of you can come and see. It's actually on their dock, our property line. So our property line extends another 8 inches onto their dock, which maybe they're unaware of because this survey was just done about 8 or 9 months ago at the request of Mr. Guy. So the survey is, the marker's there. Everybody can go and see it. It's on their dock. So we do have an extra 6 or 8 inches that would cover what they're arguing about.
Thank you. Do any members of the board have any questions for the staff, the applicant, or anyone who has spoken on this item?
My question is, I hear two sizes. One is 75 feet, the other is 83 feet. Which is correct?
Mr. Chairman, I think you're referring to the length of the existing dock. That should be shown on the survey. I don't know the answer to that question, but if the clerk has a copy of the survey that can bring that up, that should answer the question, I would think, assuming that the survey dimensions the dock.
My concern is the veracity of each statement. We have one party saying it's 83 feet, another party saying it's 75 feet. I'd like to know what the actual true length is.
Al, can I speak to this?
Sure.
Kelly, can you please put up the what I gave you, which was the picture of the picture from the submission for the app, this one right here. Yeah, this one with the red lines on it, yeah. The dock that is currently there, the concrete dock, you can see it on this is the dock that was submitted and approved, and that was what was constructed. Mr. Guy came, he looked at it, he approved it. So the only thing I can say is that the town has already approved the construction of this dock. So what the size of the dock, the position of the dock was approved by the town and the construction officials in this town. And that was completed. Once we completed that, there was no consideration at the time of putting in a floating dock. It was after we completed this construction, we had the thought that we would like to be able to launch a kayak and a paddleboard. And we then sought to find a location to do that. So when this was constructed, that was not a consideration at the time. Number one. Number two has been some question of us moving our existing boat lift. The boat lift was never moved. The boat lift was removed for the seawall construction, and then it was put back in. That was done by the seawall construction company. I had I instructed them to put it back where it was, and that was up to them to put it back as close as they could to where they thought it was previously located.
The ingress and egress of the boat onto the lift is from the west.
From the west. The only way that the boat can come off the lift would be to the west, because obviously the engine is sticking down. You can't drive through the lift and go out
Correct.
to the east. So as far as the size of the dock, the proposed positioning of the dock, this is what it was. Mr. Guy came back. I assume he had all this documentation. He did not raise any issues with size of the dock or anything like that, and it was approved and signed off by the town.
Thank you.
Can I say it first? And then you? Sure. The Fornatori again, 7 Elm K. The dock in question is really not the issue. It's how much room is left after the building of the dock. The Throwers own the entire lot, all 165 feet from our property line to the intercoastal, no question about that. It's a matter of how much room was left after the building of the dock. It's not 14 feet as stated in their submission. It's not 13 feet either. According to everything that we know and have been told, it's 12 feet. So if it's 12 feet, that matches the permit that they were granted to construct, and the remaining measurement between the end of the dock and the property line is relevant, not the length of the dock. They can build the dock from 12 feet all the way out to the intercoastal. It's their property, they can do what they want. But how much is left between the property line and the end of the dock? And the other thing is, we don't have a dock. So I don't know what she's referring to, that there's a mark on the dock. We don't have a dock. We have a seawall that was surveyed and installed, and it was the existing seawall being replaced by sheet pile seawall. And there's a line of distinction between the two properties that were marked with pegs back when, and that's how the cap to the seawall was made. Thank you.
Good morning, David Glickman, attorney for the Fornatoris. Just in response to Member Sloat's question, which I didn't hear a specific answer to, I'd like to direct the board to the survey in our Exhibit D of our submission. If the town clerk may give assistance, please, in bringing up Exhibit D from our submission. And I'd just like to point out to the board the measurements in this survey. And so if you can zoom in to the very bottom, even a little bit further, please. Yeah, to the bottom there. So you can see the word concrete. That's the concrete dock, and to the left of that is the wood dock, and you can see that the measurement there is 83.20 feet. And so, based on Member Sloat's question, we just wanted to direct the board to this survey, which is, again, is Exhibit D in our presentation, and I hope that provides clarity on your question, Member. And please recall, board, this is not necessarily about the measurements, it's also about the 10 criteria. And so please do consider this.
So this shows 14 feet from the dock.
It does.
The prior survey showed 12. So how do you reconcile it?
The way we reconcile it is when you add up the total amount of footage of that seawall, 14 and the 83 and the remaining amount, it actually comes to 170 when the seawall is actually 165, which is why we believe the 14 is inaccurate.
Could you repeat that rationale again? I didn't quite follow.
Sure. So the accurate distance of the seawall on that south side of the property is actually 165 feet. And when you add up the footage in this survey, the 83 and change plus the 14 plus the distance to the left of the dock, it actually comes to 170, which is over the 165. And so there's an error in there somewhere. And given the various distances that have been provided by the throwers of that what shows as a 14-foot distance, we believe the error is in that section.
And so the other survey showing 12 feet, you would agree is more accurate?
That's our position, yes, sir.
Thank you.
Thank you.
Well, if there's an error in this, is there an error in the 83 feet? You know, you say one part is an error, the other part is fine. What is the honest survey saying?
Well, again, we have competing surveys, right? So we have surveys that have been provided that show the 14-foot section as 12 feet, as 12.7 feet, as 13 feet, and as 14 feet. And so it's difficult to say, but clearly the variance has occurred within that 14-foot section, or what is really a 12-foot section. And so because of the variances in the surveys regarding that section, I don't believe there have been any other variances in the surveys regarding the length of the actual dock. The 83-foot figure, we haven't identified any variances in multiple surveys on that figure. The variances have occurred in connection with the space in question, varying from 12 feet up to 14 feet. And that's why we believe the error lies there.
So this is a matter of question here. When you have multiple surveys with different numbers, the decision is based on a matter of convenience.
I think that's accurate. And again, the board's obligated to consider whether each of these three variances meet all 10 criteria. And for our presentation, we take the position that they do not. Thank you. And
I have a question to the town. Has anybody looked into whether or not the flowers are indeed exempt?
Mr. Chairman, not to my knowledge.
Okay. And then has
Dr.
anybody?
Raquel,
Yes.
if I may, Mr. Chairman. There's two deck-rent laws that have been talked about today. One law does not go into effect until July 1st of 2023. That's the law that I looked at, that law. As I believe was represented, and I agree with, even assuming that law is applicable to this floating platform, it does not prohibit the town from enforcing its setback at a minimum. Furthermore, assuming that the floating dock meets all the criteria, and there's a laundry list of criteria that they have to meet, it doesn't prevent the town from putting a limitation on the height of what can be built on that, because those issues are not addressed in the law. Now, they may be able, if they meet the laundry list of criteria starting July 1st of this year, they may be able to be exempt in terms of that floating structure extending out 5 feet. But the law's not in effect yet. It has been signed by the governor, so it's just waiting to become effective. If the variance is not approved today, they can certainly come back to the town once this new law goes into effect and ask that the town consider following that new law in terms to what it doesn't impact as of the town's regulations. The existing law that the new law is amending as of July 1st doesn't give them the ability to be exempt from the three issues that are before you today.
Another question for you is, has anybody taken the time to look at what class 3 waters are? Which is what is in the EPA?
Mr. Chairman, no, that was not part of the variance application, and not understanding how that's relevant to the.
Well, I think it's very relevant because class 3 waters are waters that have a lot of wake, a lot of wind, and a lot of movement of the waters, which is noted by the EPA, and therefore could show a hardship that this person, the owner of the property, has no control over the class of the waters, and therefore moving your boat lift to a more safe place because of the waterway.
Mr. Chair,
Would be
may I just step in real quick? This board is charged with the duty to be impartial hearing officers.
Correct.
All evidence and testimony that's to be presented must come from the applicant, or in this case, an affected party. If you have questions about the applicability of a law, that question should be brought to the applicant or the affected party so that this board maintains its impartial status. So if you have a question about the impact of an EPA law, I would suggest asking that to both the applicant and the affected party's attorney to allow them to respond. Because I don't want this board to face a challenge by bringing up issues that have not been presented yet by the applicant or the affected party.
Thank you.
If I may.
Yes.
One question in the back of my mind, and I'm new, so I may be totally off base, but I'm just wondering, as I was hearing all the discussion about dimensions and all this, if the applicant wanted to install a 8-foot by 8-foot floating platform to the east, would they not have any need? I mean, would the issue be gone? Because now there's no question that the setback is clearly more than 3 feet. They wouldn't extend out into the waterway more than 10 feet. That would leave the issue of the structure, leaving that aside. I just kept the whole time thinking here, well, if it was 8 by 8 feet, does all this go away? And so I don't have any
Mr.
comments.
Chair, if I may respond. The prior building official pointed out these 3 issues. The one issue with extending out to the waterway is there's a 5-foot limitation. So it would have to be a 5'8" in order to comply with that.
Okay, well, assuming the 8 by 8, but starting July 2nd, an 8 by 8 would work.
Assuming they meet all the criteria of the new law.
Right, okay, so that's my point. And I'll just go as far to say that because they didn't propose the 8 by 8, they are putting it is as a result of their actions. Just leave it at that. Thank you.
Any further questions for me?
No, thank you.
Very good. Thank you, members.
Last comment.
Yeah, I want to address the survey. Kelly, could you please move over so we can see the date on the survey? Okay, this was done by a licensed surveyor. I'm sorry, I think it's the other way. This is done by a licensed surveyor from the state of Florida. He did the survey and gave it to me, and I submitted it to Mr. Guy, and when he did that, I noticed that he did not mark the distance from the dock to the property line. So because of that being so important in this case, I asked him to come back. So he came back to the property. He specifically measured the distance from the property line to the dock, and that's why it's marked as 14 feet 2 inches. So that is accurate. That is a licensed surveyor. The other survey that had been submitted was done when we bought this property in 2010. So that survey is 13 years old. This is a very current survey, and it was done last summer. I can't see the date on it, but it was done in 2022. So this is a very current and accurate survey of the space that's available.
Mr. Chair. I'm sorry, but unless I'm mistaken, this survey is not sealed or signed, and the other one was.
Okay, well, this was submitted by the Fortunas. This is not my document.
Excuse me.
Excuse me, I'm sorry, I'm speaking. I did submit a signed and sealed survey to Mr. Guy, and the town has a copy of that as part of the permit application.
And that one shows 12 feet.
No, it did not. I'm sorry. I would wish to correct you. This survey was the one that was done in 2022. The survey that being referenced that showed 12 feet was done in 2010. They're not the same surveys.
I understand, but this one's not signed or sealed.
This is a copy of a survey that the objecting applicant has submitted. I didn't submit this. The one I submitted was signed and sealed, and I'd be happy to provide it. The town has it. So there's no doubt about that. It was part of the permit application to Mr. Guy. He has that. He has that. This was signed and sealed. He has all the other required documents were signed and sealed. And we also did submit, and Ms. Godot knows this, we did submit our proof of the exemption from the state of Florida for the dock. We obtained the exemption from the DEP of Florida.
There's a seal on this.
There's a
I see.
seal.
Thank
Can you
Scroll
state,
down.
can you state the beginning of what you were saying again, the measurements,
There is one on the
before,
bottom.
what you started off with?
Gotta use the mic.
The original survey that was done in 2022 by the surveyor, he gave me the survey, sent it to me, I looked at it, I sent it to Mr. Guy, and he raised the same question. He said, there's not enough room for the dock, you don't have the space. So then, at that point, I then proceeded to say, you have to come back and you have to measure, and we need an accurate measurement. And that's where he did and he came back and said, it's 14.2 feet. And that's where he
From the
ended it,
property line.
from the dock to the
Move
property.
it so we can see the seal.
You keep moving it away from the seal.
Right,
There
but
it
now
is.
make it smaller, so we can see the whole page.
Okay, Kelly is showing you two different documents. This document that she's focusing on now shows the engineer who located the floating dock. And this is the application, part of the application to the Department of Environmental Protection for the state of Florida. Okay, they use that. This is the survey right here. Now you're looking at the survey, okay? So, I'm happy to provide a signed and sealed copy, but believe me, this is an accurate survey and it is signed by the gentleman who did it. So nobody's pulling anything here. These are the numbers.
Thank you. Thank you, Mr. Farrell. I now declare this quasi judicial hearing closed.
Excuse me, I have one more. I would just like, I'm Nancy Fornatora, 7 Inland Quay. I have just one question. Is the size of the thrower's dock 165 feet, which they have said in every presentation they've made, or is it 170 feet, which comes when you put a 14-foot? It's not irrelevant. It happens to make the difference about whether it's 12 feet or 14 feet in that area. And I believe it to be 12 feet. The length of their seawall is 165, not 170. Thank you very much.
Mr. Chairman, I'm very confused because we have two conflicting.
If I may, on the measurement from the end of the dock to our property line, we have measured it electronically and physically, and it is 12 feet plus a couple of inches. Thank you.
I now declare this quasi judicial hearing closed. We'll now proceed with comments and deliberation by the board.
I'm very confused because we have two parties with two different sets of figures. And I don't think we can make a decision predicated upon getting mixed information. Maybe mediation is appropriate, I don't know. Or maybe another engineer needs to come in and measure.
To me, the length of the dock is inconsequential. And what matters is this floating vessel platform and the floating vessel platform clearance to the property line. Now, with the evidence that Mrs. Thrower presented today, there's maybe even more distance to the property line than previously appreciated. I don't care how long your dock is.
No,
Okay, but what I care,
total footage.
what I care about is, and my personal consideration is safety. And, you know, you have one marine engineer saying this is and I'm not a marine engineer, but we have one marine engineer saying this is absolutely the safest place to put this platform. As living on the water, I don't know what class waters they are, but living on the water and common sense would say, I'm not getting on this in the intracoastal. I have neighbors with boat lifts on the intracoastal. They're not comfortable with it. Okay. So certainly in a smaller vessel like a kayak or paddleboard, it would seem to me judicious from a safety perspective to move this as far away from the intracoastal and a no-wake zone as possible. Now, that being considered, I'm not, I also like to consider the Fortuna's issues, but their issue is that it's unsightly, has a negative effect on their property value. When I was at the property, you could not see this platform from the surface. Something that you cannot see, I don't know how it has a negative effect on the property value. In addition, Mr. Glickman brought up these devices that lower kayaks into the water, which I did research, and they don't work from a 10-foot. They don't work from 10 feet. They work from like a dock down into the water. So it's just a matter of a few feet. The other issue, and everyone's raising dock because of rising tides and global warming, is that the weights of these, forget, these motorized vehicles, but wave runners or whatnot. But even kayaks are very heavy. You're not gonna raise them lower than 10 feet. I think I'm a pretty strong guy. But you know what? That's a hefty ask. So certainly I would think that keeping them on the platform is, again, the safest way to do this. Superstructure is a little misnomer. I mean, if this thing is under 4 feet high and secures their vessels to the platform, I think that's the responsible thing to do. I don't want to see, when I'm boating, when I'm kayaking, I don't want to see a vessel become a navigational hazard. I get angry with pieces of 2x4. Right. So, anyways, all joking aside, I think we have to be judicious as to see what's best for the community as a whole. And I think, in my concern, safety is the number one issue. Art?
Okay, I'm probably on the minority here, but a couple of things. First of all, I stepped off the distance of from where the ladder is to the property line. It's approximately 12 feet. I mean, I do that a lot. I know what my measurement of my foot is. So I have no question that it's 12 feet. It's not 14 feet. With respect to the view from their house, I would take the same, they can't see it. However, I believe they said that they put up that extra hedge so that they would not see it. Okay? No, not the lift. So they didn't see the floating dock.
No, they put up the hedge because of the lift.
Okay, but still, it's going to be within that. I go back to my point of, if it was 8 feet by 8 feet, there's no issue here. And then we could all say, I certainly would say, it's better for the kayaks to be able to set it up there. It wouldn't be in their sight. So I would grant the variance for that for safety reasons. The other thing is I stayed out there and watched as 2 boats went by to see how things were moving. I mean, it's not stabilized at this point anyway. So personally, and I'm not a boater, I don't know anything about this. I didn't see, and then I watched the water raising on the east side. It was still going up and down on the east side. So the other issue, and that my question is, they gave all these examples of other docks that clearly were within the less than the 3 feet or 5 foot. So my question for the attorney is, how does that play into this? Because I know that one time when I was on an HOA board, if you didn't enforce it here, you don't have the right to enforce it there. So I don't know how all that plays into this analysis, and thank you. That's all I have to say about anything. Thank you. Bye.
Mr. Chair, if I can respond to the question on the other properties. That issue comes up a lot, especially in code enforcement, in terms of, well, my neighbor down the street has it, so I should be able to. What we don't know is the neighbor's circumstances. We don't know if there was a permit or if they truly are exempt. You know, in the code, if it's moored and not attached to the seawall, it doesn't need a permit. We also don't know if they've been notified of a code enforcement action against them. So it's oftentimes difficult to say, just because my neighbor has it, I should be allowed to have it too. Certainly the case exists that there may be floating docks out there that the town hasn't taken any action on. That wouldn't be surprising. That pretty much happens everywhere in terms of, you know, things get erected that don't have the proper permits or not, and if whether or not the town then has the capacity to address those.
Well, you know, I kind of agree with where you were going, Art, with the 8x8 or 9x9, and it seems like a compromise where we wouldn't be here, you know, otherwise. So, you know, I don't know why it has to be 10x10. Is there a reason it has to be 10x10? It can't be 9x9 or 8x8? I mean, is that?
Can I answer that question about the size?
You have to open back up the hearing.
You want to hear that answer?
You want to hear the answer?
No.
So, you know, the other option that we have is in a motion, whatever motion is brought forward.
Can you use the mic, please?
I'm sorry. The other option that we have going forward is whatever motion is made, you don't have to designate the size of the platform. What you could do is designate that we give a variance 3 feet from the property line. And then, you know, if they can get 3 feet from the property line with a 10x10, then that's their option. Or if they have to reduce the size of the platform, then that's the other issue. Now, we could also say, in the consideration, if this is, you know, if 403.893 is going to be revised, and it looks like it's going to be revised, it's already signed by the governor, it's just waiting for the vote from the state legislature. We could say that the current platform has to stay in its current position until July. I mean, we could put that restriction on it.
I think those are both excellent suggestions. The only question I have is that we still have this controversy, or I don't know whether we have a controversy or not, because we still have a controversy whether it's 14 feet or 12 feet. And so I don't know how we resolve that. But what I would say, again, is the survey that shows the 14 feet, the one that we have in front of us, that is not signed and certified. The one that is signed and certified is the page below. Now, I'm not an engineer, so I don't know whether when the surveys, each page is stamped. I'm pretty sure in architectural plans, every page is stamped. I could be correct or not correct about that. I don't know how we resolve that. If we assume, I don't know how we put that into effect, but if we're able to make it clear that it's based on this width to do the two things you propose, I personally think that's an excellent idea.
I'd like to make some comments, Mr. Chairman. First of all, my assumption is, and Chris, you can tell me if I'm wrong, we have to go by what the packet presented, and it says in the packet that it's the variance is to bring within 3 feet of the property line. Is that correct?
That's correct.
Okay. Number two, we have a ruler that says.
Let me correct that. They would have to comply with the request to have the 3 feet from the property line. If the variance is granted and they put the floating dock back in place and they can't show that they have the 3 feet between that and the property line, they're not in compliance with the variance, and they will then have to modify it or again remove it.
That makes perfect sense. And So, and, I think we would all agree on that. If it's not within 3 feet, then the variance is even incorrect. Granting the variance would be incorrect, and that would be a problem. Number 2, we have this question about lowering property values. Well, we have a realtor that says it won't, and we have a realtor that says it will. Just like we have a survey that says one thing, and we have a survey that says another thing. So the question is what do we, as a board or as an individual, choose to believe there? I walk the property. As far as I'm concerned, let's put it, and the reason I'm sorry, I didn't mean to interrupt you earlier. The reason I was a little concerned is if that floating dock's only been in there for what, 2 years, what was it, 2 or 3 years? There's no way that hedge got that big in 2 years.
No,
That's my point.
You made the excellent point that that was put in at the time the dock or the
lift.
boat lift went in. So I understand that too.
Okay, number 3, or 4 maybe. I live on the water and, as Bruce does, and we see the currents and the strong, weather that can come in and floating docks can go up and down, especially on the weekends when there's a lot of boats and things like that. And the narrower the canal, the more wakes, the wider the canal, the less wakes for them. So, and personally, as a safety issue, I think it's 100% correct that if I had the same instincts and I lived down the corner, I would want to tuck that as far east as I can. On a kayak especially, on a jet ski, it probably wouldn't matter to me that much because I can get off on it because I do have jet skis. But on a kayak and a paddle board, and I have grandchildren, I had grandchildren and things like that, that would be a concern for me. I would want it to be as far away from the moving of the waters as I can. I know that, Chrissy, and maybe I'm incorrect, but the only reason I brought up the class 3 is it is in the packet as far as the EPA is concerned, and they noted that it was, so that's the only reason I did bring it up to begin with. And then lastly, it's a matter of, and I agree, I was asking what you said, and I agree with you, and I'm a little sketchy in the gray zone when it comes to what Christy addressed, how she answered it. And the reason is there's floating docks all over the town. And I can tell you this from experience of being on the water as much as very few, if any, are moored. They're all connected to the seawalls. And the reason they are is because you have PVC and it works so that it goes up and down with the tides. Lastly, to me, being what Bruce said is correct in the sense where the only way you're ever going to see that is if it's a king tide and you have the kayak on there and you have the paddleboard on there and you look around the hedge. That's the reality of the situation there. So there's all these things that come into play, and I understand them because we all have neighbors and we all have our challenges. And then lastly, you have one real estate letter and 3 neighbors' letters that are all in favor of it being there. So how do we decide to go here as opposed to here when, as far as I'm concerned, the hardship is there. I don't see any criteria that they didn't meet. The 10 feet out, for example, the float on 10 feet out, it's supposed to be 5 feet. Well, if you look at the property closely, there's dolphin pylons beyond that.
You're right, they're within the boundaries of their lift.
Right.
Yeah.
So therefore,
So they're not
it's
creating
gonna be
any hazard.
navigational hazard
That's correct.
whatsoever. So
That's correct.
that's it.
So I'll now entertain a motion on item number 1.
Mr. Chair, I move that we accept the petitioner's request for item number 1.
Okay.
Do you have to do these separately? Is that how we have to do it?
Yes, separate motions and votes on each variance.
So,
The side setback is one.
yeah, so to allow the platform within 3 feet of the side lot line.
Correct. The only reason I asked the size of the dock before is was trying to be very gentle, because we had the 14-foot and the 12. As long as it's about 3 feet, I'm very satisfied.
Okay. Yeah, right. And that's for the down to this side, evidently now where the survey line is, because evidently that's in play here as well. But the motion is for approval of the variance to allow the platform within 3 feet of the side lot line.
Yes, correct.
Of the property line of number 7.
of number 7.
So you're saying it's okay, what you're proposing is that it's okay for the floating dock or whatever to be less than 3 feet from the property?
No,
Within-
3 feet.
Within 3 feet. That's
No,
what the-
no closer than 3 feet.
No, it can't get closer.
Nope. No closer than
Well,
3.
what I read is
3 feet
allow
off the side
platform to be within 3 feet of the property line. So that's the request. I don't know how to rephrase it.
Say no closer than 3 feet.
No closer.
Actually, that's,
But that's not what variance 1 says.
it's within 3 feet, yeah. You say 3 feet.
Am I understanding this wrong? I mean,
No, I'm waiting for Christie.
I'm actually just looking at the application to see how it's phrased on the actual application. It is phrased to be within 3 feet of the property line, so what then that would allow, if you grant it, is it could be up to the property line.
correct. Yeah.
So if this board grants it within 3 feet, within 3 feet would be 1 foot, 2 foot, or right up against.
Oh, I see what you're saying.
So you want to rephrase the motion?
I move that we allow the platform to be no less or than 3 feet from the property line.
No closer.
So in effect, I don't think you need to do that. What you are saying is you are denying variance 1. So you don't put that other stuff on.
The way variance 1 is written is very confusing, so I withdraw the motion and let's see what happens.
Okay, I make a motion because my understanding is, right now, the code says it has to be at least 3 feet from the property line. They're requesting a variance to be less than 3 feet. Therefore, I think what you were saying and what I'm saying is we deny variance 1.
If I may, Mr. Chair, correct, it's a 10-foot setback. So the
Not
reason
3.
they're asking for the variance is to be within that 10-foot setback. So that's why the original variance request was a 3-foot variance. Apparently now they're asking to be even closer than encroaching 7 feet into the setback.
That's not clear.
Aren't you,
All the way up to the
no, aren't you
property.
talking
No,
about into the, extending the distance from the?
There's 3 different issues. So the first issue is that with all docks, they have to comply with a 10-foot setback to the neighbor's property line, right? So the first variance that we've been discussing is to allow them to encroach into that 10-foot setback. What's been sort of that issue is how far they need to encroach into that setback. Well, as we all have just realized, the application is asking for them to be able to be within 3 feet of the property line, which would mean that they're requesting essentially to be allowed to be up to the property line, but within that 3 feet of the property line. So basically asking you to remove a setback.
Mr. Chairman,
Yeah,
I didn't follow that.
if I can clarify a little bit, the introduction to the staff report on the request, the applicant did clarify in the application that it was within 3 feet. However, the clarification was that it was a variance of 7 feet from the side setback. So that if granted, at least I believe the intent was that the variance would be to allow a 3-foot setback for the floating
That's how I
platform.
read it.
That's how I read it.
Yeah.
That's basically how I read it.
It was perhaps poorly worded in
No
my
less.
apologies, but,
No less than 3 feet.
yes, sir.
So normally there's a 10-foot setback for docks and platforms. So this is, the variances, so obviously with the size of the dock, it can't be 10 feet. So they want a 3-foot setback, and that's what the variance is about. But the way it's worded is not clear. So
Are we talking, I'm sorry, are we talking the dock or the floating dock?
the floating platform. The floating platform within the 10-foot setback from the property line. So what's on the table now is a proposal for a variance approval to allow the floating platform to be within 3 feet of the property side.
No less than 3 feet.
No less than 3 feet.
No less, not within, but no less than.
So would you like to restate your motion?
Well, how to do it.
Can I ask one question? I'm sorry.
The
So
7-foot
what,
variance.
Yeah.
From the side setback.
We're reading.
I'd say 3 feet from the property line.
Right, I agree.
Right.
I think that's the better way to do it.
so are we saying that the current code says that there can be nothing within 10 feet of the property line?
Correct. Under the section 6477, when it talks specifically about floating platforms or docks, it says that they have to conform to the setback requirements established in paragraph B. And in paragraph B, it says that it cannot, cannot extend closer than 10 feet to the lot line of any adjacent lot, or closer than 10 feet to the lot line extended beyond said property line on a line perpendicular to the seawall.
Okay, so let me be not so polite here to say that if the code requires 10 feet and they're asking for 3 feet, that this document should have been written in a way that it was very clear of what was being asked for here, because that sheds it on a whole new light. So they're asking to take a 10-foot setback down to 3 feet. When one would read this document, my assumption was that the permitted setback was 3 feet, and they were now trying to be within the 3 feet. So that's causing all sorts of issues.
Mr. Chairman, if I may let me just read to you from the page 1 of the staff report under the request. It says the applicant is requesting a variance from section 64-77B to allow a floating vessel platform to be located at 3 feet from the property line and extending 11 feet into the waterway line. This would require a variance of 7 feet from the 10-foot setback from the property line and a variance of 6 feet from the 5-foot maximum into the waterway line. The applicant is additionally requesting a variance from section 6477D to allow a floating vessel platform to have a kayak rack built atop it. This would require variance of allowance of superstructure. I hope that clarifies.
Thank you. Yeah, the very first paragraph of the request.
Under the background.
So the floating dock can't be any closer than 3 feet from the property line.
Mr. Chairman,
That's what it is.
I have another problem. The petitioner said that the property line on the documents we have is not a valid property line. The property line extends further into number 7's property. So I don't know what we're talking about. The property line that she says exists, or the property line that's on the documents that we have.
Not my problem.
So
Exactly, not a problem.
when we say property line, that could be a legal property line.
Absolutely, it should be a legal property line.
Well,
But I'm not a surveyor.
right, and therefore I withdraw my motion and let somebody else make it.
Okay.
I'll make the motion. I move that the floating dock, this variance be approved based on the description of the floating dock being no closer than 3 feet to the property line.
Side lot line.
Sideline, yes, side
Okay.
setback.
Which property line are you talking about?
That's not our concern, that's up to the surveyors.
Could you,
And ultimately, what would happen is the town would go back out there and measure, find a survey, and based it on that, they would either have to move it, or the property line would be satisfied.
I'll second.
Mr. Chair, what I would recommend, since this obviously is an issue, is that with if this is approved with the installation, that the property owner submit a signed and sealed survey that shows that it is not closer than 3 feet from the property line. That way, there'll be a signed and sealed survey to show that it satisfies the requirements of a variance and not put that requirement on the town in terms of getting a official survey to show that.
Want to add that to your motion?
So the condition would be that if this is approved, that they will have to provide a signed and sealed survey to show that the floating platform is not within 3 feet of the property line.
I make that motion amended to that.
I second.
Just one comment. I'm going to support the motion, but I'm basing my support on the fact that the folks who were opposed to this did not seem to have any objection if it is 3 feet away. Thank you.
Member Lipscomb?
I agree, I support it as well.
Yeah.
Put your mic on.
I support the motion as well.
Member Slow?
Aye.
Member Hendon?
Aye.
Member Zee?
Aye.
And Member Martell?
Aye.
The second variance issue is to allow the platform to extend 11 feet into the waterway line, which was a variance of 6 feet from the maximum extension of 5 feet, which is the current allowance for docks. Because of the location in my site visit, this is adjacent to their boat lift, and they have a dolphin piling, and the boat lift extends beyond this, so there's no navigational hazard that the platform currently causes. So would someone like to make a motion?
I'd like to make a motion that we approve the variance number 2, which allows the floating dock to extend an additional 6 feet beyond the 5 feet of the current code.
Second.
I support it.
Well,
As well.
she's got
Oh,
a,
all right.
Member
Counselor?
Zee? Member Zee?
Can I just make a quick comment? You would raise the point about referencing the passage of the new law, of the signing of the new law. And I think that if we make it subject to that, that will sort of remove the ability of anybody to contest that action by the board, perhaps.
Mr. Chair, if I may, my only concern with that is there's, like I said, a laundry list of items that they have to comply with to say that they're exempt under that. It would exempt them from the FDEP permit. So if this variance is conditioned on them satisfying that exemption, they may not be able to satisfy it.
Okay.
And so they would have to come back here to ask for the variance again.
I don't want that to happen.
So I'm just throwing that out there. You can certainly condition on it, but I don't know that they'll be able to meet all the requirements. So.
And they had to do with the initial permitting to begin with, which they already did. So, Town Clerk?
Okay, motion as is. Member Zee?
Aye.
Member Martell?
Aye.
Member Slow?
Aye.
Member Lipscomb?
Aye.
And Chair Hendon?
Aye. The third variance is to allow the rack for kayak storage. I already expressed my opinion. The only, whoever makes the motion, issue I have is currently the kayak, instead of saying kayak storage, I would put a provision of the throwers that it's no higher than 4 feet. I would say to allow the current structure, but nothing added on top. So it remains out of visual line of sight.
Can I add something as well?
Sure.
Also, so I think we should add in there, it doesn't hang over to the east. Like I think you all brought up that the rack does hang like 1.5 to 2 feet off the dock, so it doesn't encroach within that 3 feet. So either out in front or to the west, if that makes sense.
Christie, I have a quick question. Sorry. The way I read and maybe you can read that last, the variance, how it was written, because there's a wording there that's a little bit bugging me there. About the rack.
The applicant is additionally requesting a variance from section 6477B to allow a floating vessel platform to have a kayak rack built atop it. My apologies. This would require a variance of the allowance of superstructure.
Okay, and so therefore my comment is, and Chrissy, you can tell me whether this is just nitpicking or not. The rack that they have is on the top of the floating dock. It's attached to the side. It's not on top of it at all. If you look at some of the other ones that they show pictures of, it's literally racks that sit on top of floating docks. And this is kind of like a cantilever off to the side that comes up. Therefore, probably is the reason why it doesn't extend 4 feet above. So I'm not sure if a top or alongside makes a difference, but when you look at the pictures of it and you look at it on property, it's not a top. So that's just my opinion.
I believe the applicant had mentioned during testimony in the past that currently it's on the east side of the platform, that they'd be willing to put it on the west side of the platform. So it addresses not only hanging over to the east, but it would be hanging over on their property. It would achieve the same function of storing it and not having to bring these vessels down 10 feet from their cap, but would also secure their vessels and not be navigational hazards.
So do we want to say that within the 3 feet, it can't be within 3 feet, and that includes both the dock and anything hanging
Correct.
onto it?
Okay.
Mr. Chair, I think the issue with the superstructure, from my experience at other coastal communities, is to prevent the building of ideally some kind of root structure on a dock. So I think whether or not it's built from around it or on top of it, it's the same intent, that the idea is not to have any kind of structures on top of the dock. So if the motion is to approve, perhaps the condition that there be a limitation on the actual structure. Now, obviously, from what I've seen, the pictures, when the kayaks go in there, I think they actually stick up higher, so it would just be applicable to that actual structure.
Correct.
And then a limitation that it not cause any further encroachment into the side setback. And then if they want to move it to the east or west, depending on what the result is.
I should have been a lawyer. I'm just kidding. Trust me, I'm just kidding.
I so move.
You want to make the motion?
I move whatever was just said.
No.
So the structure would be allowed. The structure could not be taller than 5 feet.
4.
I'm sorry, 4 feet, thank you. And that the structure or anything put on it could not encroach into the 3 feet that was allowed under the initial variance.
That's a motion.
That's my motion.
Second.
Town clerk?
Member Sloat?
Aye.
Member Liscum?
Aye.
Member Z?
Aye.
Member Martell?
Aye.
And Chair Henry.
Aye.
Chair, before you adjourn, I'd like to make one comment.
Sure, sir.
So what I want to do is I want to apologize to staff for my comment that the report was not accurate. I didn't have those pages in front of me today, so I withdraw that, and thank you for your wording. I apologize.
Mr. Chair, if I may add one thing. The town commission did approve at its June meeting to change the ordinance for this board to allow for continuance up to 180 days.
Oh, true.
So that will be forthcoming. I do need to address with planning and zoning. I didn't even get a lot of other things on planning and zoning yesterday. So, but that will be forthcoming.
Thank you very much.
Well,
Meeting adjourned.
Good meeting. Good seeing you again.